Good morning, everybody.
Good morning.
Morning.
Good morning. Good morning, everyone.
Morning.
Good morning.
Good morning, all.
Good morning.
Good morning, everyone.
Good morning.
Good morning.
Morning.
Good morning. I hope everybody had a chance to read at least 3 of the cases. Asking for too much, eh? At least one then.
That's more like it.
Okay, one. All right, one. Okay, so today we're going to talk about employee relations and trade unions. And you see, I sent you some cases on trade unions and employees that were dismissed. So what we're going to do is just go through the procedural part of it, and then we're going to jump into the cases. So the trade union, how many of you have read the Industrial Relations Act? Not really, eh?
I perused it.
Okay, all right. Well, that's good enough. Okay, so in the Industrial Relations Act, it defines the trade union as any combination or association of employers or employees, whether temporary or permanent, and the principal object of which are the protection and furtherance of lawful interests of its members, who in the case of trade union of employees are employees, and in the case of trade union of employers are employers. And so you'd see even in the United States recently, there's been some movement towards unionizing staff. Starbucks is the latest one. They had one branch that did it, and then I think 3 more were added in last week, as people are looking for more fairness on the job. So the Industrial Relations Act outlines the process and governs the practice of the registration and control of trade unions in the Bahamas. And in order to be lawful, a trade union must be registered by the registrar of trade unions in the Ministry of Labor. And of course, that's under certain prescribed conditions, and that's regarding membership purposes and other related factors. It is unlawful for a person to participate in any activity of a trade union that is not registered by the registrar. So freedom of association is of course enshrined in our Constitution in Article 24, and that gives any person the right to exercise their freedom for peaceful assembly and association with other persons, and to form and belong to political parties and trade unions or other associations for the protection of their interests. However, that freedom of association and assembly must be viewed and treated within the context of the restrictions imposed by what is considered reasonably required under the provisions of the Constitution. And these prohibitions in the interest of defense, public order, public policy, public health, public safety, public morality, and for the purpose of protecting the rights and freedoms of other persons. Restrictions are also posed upon persons holding office under the Crown and members of a disciplined force, or in the case where assembly or association is proven to not be reasonably justifiable in a democratic society. So how do you go about registering a trade union here in the Bahamas? The registrar is empowered to register a trade union. There have to be at least 15 members for a trade union of employees and at least 3 members for a trade union of employers for registration. The trade union is required to have a constitution in order to be registered. One may be adopted by reference to the model constitution in the act. The trade union must not have an unlawful purpose amongst its purposes, otherwise it shall be made void, and every trade union is required to have a registered office. The registrar may cancel the registration of any trade union that is non-compliant with the laws of the Bahamas under Section 15. Section 21 gives the registrar the power to hold election of officers for a trade union where it fails to do so. Section 20 requires there to be a secret ballot for the election and removal of officers of a trade union, the amendment of its constitution, and for any decision of a strike action, particularly by a union of employees. There are penalties under the act for persons who fraudulently provide a false statement of a trade union's constitution, or who fraudulently misrepresents that a union is registered when it is not. Once registered, a trade union have a quasi-legal personality. Properties of the trade union are vested in trustees and may be leased or owned in their names. Trade unions can also sue or be sued in the name of the trustees. There are legal capacity restrictions on who may be a member and officer of a trade union. Under the law, no person under the age of 16 is allowed to be a member of a trade union, and no person under the age of 18 can be a trustee, officer, or committee member of a trade union. So every registered trade union is required to file an annual return before the 1st of June of every year, showing its full assets and liability as at the last day of the preceding year. And this requirement is supplemental to the requirement under law for trade unions to keep proper accounts of all monies and assets and a complete list of all of its members. So since the assets, securities, and monies of the trade union are its property, it is an offense under the act for any person to fraudulently obtain possession of such property or to willfully withhold such assets or misapply such assets for any purpose other than those of the objects in the constitution of the trade union. Now, of course, there is immunity of registered trade unions. So at common law, a combination of 2 or more persons may amount to a criminal conspiracy if the object is for an unlawful act or to perform a lawful act by unlawful means. So under the Industrial Relations Act, registered trade unions are granted immunity from prosecution of conspiracy acts. For example, staging a sick-out or absence from work in protest of low wages, or using unlawful threats to encourage pay increases, provided that such acts are done in furtherance of trade dispute. And this furtherance of trade dispute was interpreted in the case of NWL Limited versus Woods. And there it stated that a trade dispute did not cease to be a dispute connected with the terms of the conditions of employment merely because the demands made by the union on the employer regarding terms and condition of employment were unreasonable or commercially impracticable. Nor did it matter that a demand was made and the dispute pursued with more than one object in mind. That of those objects, the predominant one was not the improvement of terms and conditions employment of those workers to whom the demand related. So registered trade unions are given immunity for acts done in restraint of trade. However, a strike taken, which is in restraint of trade for an unlawful purpose, will attract criminal liability and prosecution. Employers' associations are also given the same immunity under the Act in the case of an industrial lockout under the condition prescribed by the Act. With regard to liability, for purpose of procuring a breach of contract or causing physical injury, harm, or damage to a person or property, the Act gives registered trade unions immunity from liability for such actions, which would ordinarily attract civil law damages at common law. So all trade unions that are registered must obtain prior consent or license from the Ministry of Labor before becoming or participating as members of a foreign labor or other organizations. So how do you recognize a trade union? Legal recognition of trade unions is made under Section 41 of the Industrial Relations Act. Section 41 sets out certain qualifications for a trade union of employees as a bargaining agent for the employees. And once those qualifications are met, an employer is legally obliged to recognize and enter into negotiations with that trade union for the collective bargaining. Failure to recognize or negotiate with a trade union under the provisions of the Act may result in the matter being reported to the Ministry of Labor for review and determination of the matter. To be recognized, a trade union normally writes to an employer requesting to be recognized and stating the specific bargaining unit that it wishes to represent. In the written communication to the employer seeking recognition, the trade union must stipulate that it has 50% of the employees in the bargaining unit that it seeks to represent in its membership or in good standing. A copy of the written request is also forwarded to the Minister of Labor for notation. The employer then has 14 days or longer, if it is mutually agreed, of the date of receipt of the letter requesting recognition to give notice in writing to the trade union of its decision to either grant or deny the request for recognition. A copy of the employer's rejection is required to be sent to the Minister of Labor by the employer, specifying his reasons for the rejection. And similarly, the employer must send a copy of its agreement to recognize the trade union to the Minister of Labor. So under the Acts, under Section 42, a trade union whose claim for recognition is rejected or deemed to be rejected by an employer has no later than 14 days after the rejection or the receipt of the notice of rejection to submit the matter to the Minister of Labor for determination. If there is only one union claiming recognition by an employer, the Minister of Labor may make a final determination, and it is not obliged or bound to hold a secret ballot or poll to make such a determination. And where there is more than one union claiming recognition, the Minister of Labor, under the provision prescribed in the Act, can take a representational count or secret ballot for the purpose of determining which union qualifies for recognition under the law. So all decisions by the Minister of Labor regarding applications and disputes relating to recognition are final and should not be inquired into in any court. The minister's decision in a recognition dispute is tantamount to the decision in a court of law. So as time is of the essence in the recognition of trade unions, a matter relating to the recognition of trade unions must be handled expeditiously and within a reasonable time. The Act also specifically sets out the time frame within which a claim for recognition of a trade union may be made. A claim for recognition as a bargaining agent for employees may be made at any time where there is no industrial agreement in force affecting employees employed by an employer and no union is recognized under the provisions of the Act as a bargaining agent. So where a union is recognized as a bargaining agent under the provisions of the Act, but there is no industrial agreement in force between the union and the employer, a claim for recognition must not be made by another until after 12 months from the date when the first mentioned union was recognized. So where an industrial agreement between an employer and a union is in force and registered under the Act, a claim for recognition by a bargaining agent by another union may not be made by another union until after the expiration of 2 years from the date of commencement of the agreement. So notwithstanding Section 44.3, where an industrial agreement between an employer and a union is registered, while a claim by another union for recognition by that employer as a bargaining agent is pending, that other union, if it succeeds in its claim for recognition, should not be bound by that agreement. The Minister of Labor determines that a union is not entitled to be recognized as the bargaining agent of the employees concerned, or where a union having made a claim for recognition withdraws its claim, such union may not make another claim for recognition until after 12 months, after being informed of the minister's determination or after the withdrawal of its claim. An employer may make an application for an injunction to prevent a tribunal from hearing and determining union complaints regarding trade union disputes. Courts of law are encouraged to exercise consideration of the practical realities of every case. And of course, it is an offense under the Act, Section 45, for an employer to dismiss, adversely affect an employee's employment, detrimentally or prejudicially adjust his position, or threaten an employee with any of the aforementioned actions because of his trade union participation or involvement as a member, officer, or delegate, or if the employee appeared as a witness in proceedings under the Act on the account of an employee's absence. So the procedure for the revocation of recognition of a trade union by an employer or upon determination of the Minister of Labor is outlined in Section 43 of the Act. Now, you know, they do have industrial agreements and they have dispute settlement procedures. But let's look at the case of Leon Cooper and Grand Bahama Power Company. Who read that one?
I'm actually on page 3 of that now.
When you sent those, Ms. Archer?
I don't have that either.
Not possible.
When you sent that? Would
Yeah.
that be Anthony Rock? When you sent that?
I sent those on Wednesday.
No,
I
I
haven't
don't have
gotten
email
any.
from you.
I
was wondering if you sent new mail. Like I be checking my mailbox every day.
No, I sent those on Wednesday.
I don't have
bring
any.
mine up
The
right now.
last
Let me
email I
see.
got from you, Ms. Archer, was March 5th. That would have been last week, Saturday. That's the last email I got from you.
No, man, I sent those.
This is Kendra, and that's and I check, like I say, I check my mailbox every day. And I check both
Got these
mailboxes.
this morning. I just
Pardon?
got these I just got these ones this morning.
I haven't gotten
serious?
any.
Which ones are we talking about?
I
Leon
sent
Cooper.
Leon Cooper and Grand Bahama
And-
Power.
And 2 for Sherry Brown. I got those. I got the
I have
4.
Anthony
Okay.
Ramming.
Okay, I got the one for Leon Cooper. I got
Okay.
that one March 9th.
Yes, I
Yes.
also got those, Wednesday.
Yeah, I got those this week.
I think the email looks like it comes from Miguel when it's sent. Because
If it's coming from Miguel, I'm never gonna get them because they never got my email address correct.
It doesn't
I
come
think-
from Miguel, it just looks like it comes from
It
Miguel.
looks
I
like
think
it.
Yeah, it looks
Yeah,
like
and
it
then the
comes
same-
from
and then the
Miguel, but
same thread.
it's the
It's
same
definitely the
class
same thread.
grouping that's used to send the email.
So that means
Yeah.
I'll never get them because they never updated my email. They still have me as KL Martin at
No, I'm saying
QX.
it comes from Miss Archer, but it looks like it comes from Miguel because it's all related to the same classroom, the same class.
Right.
I
Yeah,
don't have anything. I don't have
Kendra,
any.
Kendra, give me your email again?
KIDDEM2@outlook.com.
Hold on, it's doing its own thing again, as usual.
Ms.
Okay.
Archer, this Lyndon here, can you send it to my work email for me, please?
Because goodness. It was easy. I sent both of my emails to be corrected because for my initial email, they had me in completely wrong.
Okay, give it to me again. C. Linda, give me your work email.
Oh, sorry, C Lyndon at BMC Home.
It should come up at BM. Okay. Tell me if you have it.
Okay, I'm looking right now.
Sacha, I have already sent them 3 emails requesting that they either update my email or change it. And it still hasn't been done.
Okay,
So-
let me.
Kendra, did you get the email from Ms. Dean about the supplemental?
No,
Oh,
Oh,
because Palacious, if you look at the email that she sent, there should be one name that's highlighted in blue.
okay, I'll double check it.
Because from the last one, when Ms. Archer sent it, I said the reason you could see why my email wasn't coming up.
She resent the capstone as well as said that the makeup midterm would be next week.
No, I didn't get
Saturday.
anything.
I got that one.
I didn't get, oh my goodness.
Okay, Ms.
Tadashi.
Archer, it hasn't shown up yet.
how come? It's gone.
Tadashi.
Okay, I have no idea because I'm sitting right here looking at my email. I am in the inbox. That's
C L
that's
N I E M CHOMES.com.
CLINDEN.
Uh-huh.
Uh-huh.
CHOMES.com.
Correct.
Yep, I did.
Let me see if it didn't go into junk because sometimes the emails play crazy. No, it didn't go there. I probably just need to wait. But it's not here yet.
Okay, I just got yours, Ms. Archer.
Okay, you got it.
Okay, now it's here.
Okay, good.
Thanks.
Hold on, let me see. Okay, yeah, I just got it. Sherry Brown, Leon Cooper.
And Bahamas Customs Immigration something.
Yes.
Yeah.
I just
Okay.
got it. And again, sorry.
What?
No, I was gonna ask about my email again, my information.
I'm sending an
Because-
email now.
Because when I look at it, it's saying KL Martin at centralbankbahamas.com. That's not it. Because that should have been an I. So those email are going wherever it is they go.
I know where to go in because anything bounce back and say can't be found.
It should.
So maybe there is a KL Martin at Central Bank Bahamas somewhere there.
I'm certain there isn't. And I had asked, and then I told him change it and put it to my personal email account since that was an issue I didn't get that either. No, I haven't gotten an email from Ms. Dean from I started. Neither have I gotten an email from Miguel.
I'm sending it now. So who read Leon Cooper?
I had an opportunity to read all of them, not so much in detail, but definitely Brown, I was invested in.
Let me see which one is Brown. Oh yeah, Brown is the last one. We'll
Yeah,
discuss-
it was the
Because-
tribunal as well as the Court of Appeal.
Yeah, we're gonna do 3 of these today. 3 of these, but we're gonna start with Leon Cooper. Let me just give them just a minute just to read the introduction. And then we'll start with that one. And let me copy Miguel. Okay. All right. Let's hear our presentation on Leon Cooper. That's one that's, I know that one is not as exciting as Brown. So Leon Cooper was terminated without cause, effective on the 6th of September, 2011. The appellant contends that his termination was a breach of his rights under the industrial agreement, which governed the relationship between himself and BPL and Grand Bahama Power. The said industrial agreement became effective on the 1st of January 2000 and expired on the 1st of January 2005. And it made no provision for termination without cause. However, Section 29 of the Employment Act, which commenced in January 2002, provides for termination with or without notice. So Section 77(2) of the Employment Act shall not apply to industrial agreements registered and in operation at the commencement of the Employment Act, but shall apply once the agreement expires. So Mr. Cooper contends that notwithstanding the stipulated expiration date of the agreement, it continued to be enforced beyond the 1st of January 2005. until a new agreement was entered into. And since no new agreement was in place at the time of his termination, the Employment Act had no application to his employment or contractual relationship with Grand Bahama Power. So the question was whether Section 29 of the Employment Act, which makes provision for termination without cause, can be applied to an employment contract that makes no provision for termination without cause. So this was an appeal by Mr. Cooper, and the court held that his appeal was dismissed. They said that the rights under Section 77(2) of the Employment Act, on the expiration of the agreement on the 1st of January 2005, the Employment Act applied to that undertaking. So Section 4 of the Employment Act provides that nothing in the Employment Act shall be construed as limiting or restricting A, any greater rights or better benefits of an employee under any law, contract of employment, arrangement, or custom, or B, an employer from conferring upon any employee rights or benefits that are more favorable to an employee than the rights or benefits conferred by the Employment Act. Therefore, if greater or better benefits may be found in the individual contract of employment than those conferred by the Employment Act, then those rights and benefits prevail over the rights and benefits conferred by the Employment Act. And so the individual contract of Mr. Cooper does not contain any such provision, primarily because it does not address the issue of termination without cause, with an accompanying compensation package, rights, and benefits. So Section 29 provides what they call a minimum code to facilitate such a termination without cause. So once an employer complies with that provision to bring an employment to an end, there is no unfair dismissal claim that would lie unless the employee has better terms under his contract of employment for termination without cause. And this was not the case in Mr. Cooper's stance. So the industrial agreement had already terminated. And so the company relied on Section 29 of the Employment Act.
So he had to pay costs out of all that nice 66,000 he got.
Yes. He had to pay.
So how this reads then, that once the industrial agreement expired, then the EA was
Kicked in.
deciding, okay, and that's standard? That's the law, that's the way the law reads?
No, but this one was at the time when the act came into action. When the act came into force, that was this case. Now we have another case where the industrial agreement had expired, and we're gonna do that one next.
Okay.
I think I have
Question.
one here. Yes.
I know usually when an industrial agreement expires, it normally rarely the new one is negotiated in time to begin immediately after the expiration. So the benefits from the previous one, which I think was a part of his argument, he thought that they would continue on until the signing of the new agreement. How can an employer pick which benefits they want to continue on over some that they may not want to continue on? Like, for instance, like let's say if they were due increment, they continued to pay the increment, they continued the other benefits and other measures. Why, in his case, did they not consider that?
But even so, that would still be a part of your actual employment contract, eh? Because I know when our industrial agreements are waiting.
You got cut off.
Hello, you can hear me now?
Yes.
Okay, I was saying when our industrial agreement is up, whatever increments we're entitled to based on our appraisals, we still get it because that would be in our employment contract. So I think that is what we fall back on.
Yeah, you would fall back on the employment contract itself.
Right.
That's correct.
And that would be guided by the act until the new industrial agreement comes into effect.
Right.
Yeah.
Yet, but I know for years they didn't have one, and a lot of the union properties, they continued to follow on with the one that had expired for years ago.
There is a case that went to the court. I'll find it for next class, where there was a union agreement that had expired, and there was another one they were in the process of negotiating. And the question was whether or not they could have relied on the one that had expired. I can't remember what was the outcome, but I do have a case on that, a local case.
But that would still be the decision of the employer, right, Ms. Archer? Because
Yes,
yeah, okay.
but I've defined that one.
Yeah, because if you have an employment contract, they could decide which one to use.
Yeah, especially after it has expired. Let me see if I can find it, if I have it handy. I remember that. That was another one. I think it was BPL. Was it BPL? They have a lot of lawsuits.
I think this similar situation, Ms. Archer, is presently what's going on at Central Bank.
The same thing?
The IA is expired, but we're still functioning under the old IA until negotiation is complete for a new one to be agreed upon and signed.
Yeah, I'm trying to remember. There is a case. I have to look for that. Do you think the role of unions is still relevant?
Definitely, especially now after after pandemic.
I was just gonna say definitely.
Oh, yes.
It's still, I think it's relevant, but it's not getting the support it should have. Unions aren't getting the support it should have.
They won't because the employer wants to keep all their money, and that's always the case.
But then to employees, a lot of employees are timid because a lot of employees, so I guess in between trying to figure out, should I do what's right or should I just stay employed? That the support isn't there.
But when you look at how long it takes for a case to come up at the industrial tribunal and people are hurting, they will decide to just keep them out shut and keep working.
But then it's strength. If everyone comes together, the fist is greater than the finger. So I mean, it's a flip side.
But don't forget now, those unions have been having their challenges for years too.
Yes, they have.
And I think a lot of that comes from their mismanagement among their own ranks.
Yep.
I've never worked in an organization that was unionized. So this is all interesting to me because I've never been pro-union because I've never been exposed to them. And as an outsider, I almost feel like it's just an added level of noise.
Yeah.
Wow.
That's a good way to put it. It is
It
another.
starts internally, like you say, Lyndon. It does start because if you see we can't come together and form one mighty one, if we gotta have so much broken ones, then right away you can't be taken seriously.
Yeah.
I think the concept behind the unions, that like you said, the fist is more powerful than the finger. I think in concept it's great, but boy, execution has left a lot to be desired.
Exactly, Catherine. That's what I'm saying right now. It's that execution that's killing most of the unions. People only see the relevance in it when it's time to run to it. It's
Mhm.
like, I'm not gonna support you unless I need you to do something for me.
Right.
That's
But-
unfortunate.
But remember too, the unions lost respect years ago because no matter what the employee did, they took the employee's side. They were not objective. And
Mhm.
a lot of a lot of employers don't respect them. And so that's why they don't get the kind of recognition, and then under that, another thing is you don't know what they're getting under the table too.
Yes.
That one, the ladder is slim, that's slim.
Oh, they have their agreements. They have their agreements. You'll find that a lot of employees are saying, "Oh, the union, it ain't no use because they don't help you." That's because you don't know what agreement they've come to with the employer.
Yeah, that happens with those really big ones. When you got the smaller ones and you could watch it and you could actually scrutinize, then that's different. But those big ones, then yeah, I agree.
Yeah, yeah.
I would like to think that one of the roles of the union would be to guide employees in the proper execution of their duties and responsibilities, and not just take the employee side arbitrarily, arguing what they know wasn't proper and just in fairness for the employee to deliver to its employer.
As it should be, Catherine, as it should be.
Right.
But then you have some people who just dog it, they just won't row for everything, even when you know it's wrong.
Exactly.
And I'll say this: I was very active in the union. I was acting vice president, as a matter of fact. Well, I was vice president. I was acting president for a time, and I think that was one of the things that caused me to get well. Besides me having to resign my post, that was one of the things where I started to lose members because you have to be neutral, but then you still need to be on your people's side,
Yes.
and that's why I think unions and persons that represent unions, especially for the employer, they should then be separate from the organization. You have to learn when to put down one cap and pick up the next.
But I think they're getting better now because you can't expect to have an employer penalize when the employee is wrong. And that was, like I said, when I started the corporation all those years ago, that was the impression that I got when I first started. And when I became the shop steward, I had to tell the staff, please, yeah, the union is here to protect you, but only if you're being taken advantage of. But they were using it for a different purpose.
Because they figured they were paying viewers. So because I paying you, you must do whatever I say you must do, even if I'm wrong. That was I think that's still the impression of a lot of people for the union. The union is to represent me if I'm right or wrong. That's the impression, and that's the impression. Like you
No, but
say,
it's fine. They wanted them to give them right when they were wrong.
right? And members don't understand that, because then when you go against them to say, listen, I see the view from the employer's side, and it is, you really do need to slow down, or you really were wrong, or you don't represent me, they must pay you.
But needless to say, I was only the shop. I was fired after that too. So
You're right, and
They
that's why I say I think to be a part of that, you have to be neutral, and certain people in certain areas or departments of an organization should not be a part of any bargaining if you're not able to be neutral.
yeah.
What was a surprise for me was I wasn't aware that there were trade unions for employers. Who
Oh,
would
yeah.
who would
They
be an
have that
example of that here?
Oh,
You remember I mentioned that they had their consultants, so we had an issue going on. They called in their people as well, but when we called in ours, they called in theirs. So yes, they do have them.
So who in the Bahamas would be a trade union of employers?
Well, our person for the corporation was Mrs. Rose. She is passed. So
Okay, because I'm just trying to understand the relationship. So the industrial agreement would include employers and employees as a part of the agreement, but I for some reason I read this like the employers themselves could have a representative trade union representing them as employers, like
I don't know
employees.
them to have I don't know them to have
no, not a
a
representative.
union, but I know they have, a lot of them have lawyers. They would have really high class lawyers to represent the employer. So they'd have a particular lawyer they would use for industrial unrest.
well, I think Ms. Burroughs came from the Batelco union, and so the corporation used her on their side.
Yeah, because, you know, they use different lawyers. Catherine, I don't think they have a union of their own.
See, I got that idea because when we were reading on page 112, where it says definition of a trade union, and it just reads the lawful interests of its members, who in the case of trade unions of employees are employees, and in the case of trade union of employers are employers. So I was just thinking it's two types of trade unions, one for employees and one for employers. Not
No,
correct?
the employers, most time the employers have lawyers.
Just lawyers.
Okay, okay. So that's another bag of whatever. No offense to anyone who's in the legal practice.
No. But remember now, when you're dealing with industrial agreements, you have to go back to the document itself,
Yep.
because that's the source of the document that sets out the whole process for dispute resolution.
Mhm.
And I think one of the things, employees don't refer to that document. All they know is I have a matter and the union must take care of it.
Right. That's what I was saying. They don't revert to it.
They only read that when it comes to the money and the benefits.
Listen,
Right.
you know that, me.
Yes.
That's all they want to know. And then it's what they taking from us, what they giving us.
Yeah.
It ain't how hard you gotta fight for what it is. It's only, like you say, how much they can give us.
Right. So in every industrial agreement, it must have a procedure for conciliation and for the prevention and settlement of general disputes that may arise. So the Act makes the imposition of a mechanism for the settlement of disputes a prerequisite for registration of the industrial agreement. So the Act gives the registrar the power to register industrial agreements relating to both essential and non-essential services, and to hear matters relating to the registration of such agreements. So before an industrial agreement is signed by the parties, a draft copy is sent to the registrar for approval. And under the Act, a copy is also required to be sent to the Minister of Labor, who may make comments on the agreement, which are then forwarded to the Industrial Tribunal for review. Upon approval of the draft agreements, the Industrial Tribunal notifies the parties, who subsequently sign a final industrial agreement as approved by the tribunal, and forwards the same to it for registration. Once registered, an industrial agreement is binding on parties to the agreement and every employee within the bargaining unit. Any person succeeding, whether by virtue of a sale or other disposition, or by operation of the law to the ownership and control of the business, and any trade union recognized which succeeds the trade union that signed the agreement. So Section 53 of the Act stipulates that the following agreements, though lawful, are unenforceable by a court of law. An agreement between members of trade union restricting any member from entering into an individual agreement with an employer with regard to employment. An agreement for payment of penalty to a trade union by a person. Agreement made between the two trade unions. Agreements to apply to the union funds to provide benefit to members or to discharge any fine or penalty imposed on any member by the court, or to furnish contributions to an employer or employee, not a member of that union, in consideration of the employer or employee acting in conformity with the Constitution or resolutions of the union. It should be noted that an agreement entered into between a trade union of employers and a trade union of employees is not within the definition of an industrial agreement for the purposes of the Act. So the procedure for dispute resolution is one, you have to report the dispute to the Minister of Labor in writing. The Minister of Labor refers the parties to the dispute resolution mechanism in the industrial agreement, if one exists. If no settlement is reached after 7 days, any one of the parties may report the status of the matter to the Minister of Labor. The Minister of Labor may then refer the matter back to the parties for resolution, if he is of the opinion that all avenues and opportunities under the dispute resolution mechanism have not been exhausted. The Minister of Labor may initiate and commence a conciliation if no settlement has been reached after a further 7 days after the second referral or attempt. If after the further 16 days or the expiration of a period agreed by the parties, he is unable to achieve a settlement between the parties, the Minister of Labor shall refer the dispute to the Industrial Tribunal for determination. Where there is a settlement of the dispute due to the steps taken by the minister, a copy of the settlement signed by or on behalf of the parties is sent to the minister, who then files a copy with the Industrial Tribunal. The settlement will be binding on the parties from the date of the settlement or an agreed date by the parties. The tribunal may outline and regulate its own practice and procedure for having disputes subject to the provision of the Act, or being of the rules of the Act. Under the Act, this allows the tribunal to hear or determine any dispute before it in absence of any party who has been summoned to appear before it and has failed to do so. The tribunal is mandated to hear, inquire into, and investigate every dispute which is before it in an expeditious manner, and it may hear, receive, and consider oral or written submissions, arguments, or evidence by or on behalf of the employer or employee concerned, by the trade union concerned on behalf of the employees involved in the dispute, or by any person having wide experience in trade unionism. Upon hearing a dispute, the tribunal may remit a dispute to the parties for further consideration or discussion by them in an effort to reduce or resolve the issues related to the particular matter. In other words, it may remit the matter back to conciliation meetings with the labor board or independently as parties to the matter. They could make a provisional, interim, or final order or award in relation to the trade dispute. They can give directions regarding the hearing or determination of a trade dispute. They can award compensation to an aggrieved to proceedings before the Industrial Tribunal upon filing a complaint, application for any breach of non-compliance with an order or award. They could dismiss a matter or part of a trade dispute or other matter brought before it, or refrain from hearing or determining the matter for triviality, frivolity, or if further proceedings are deemed unnecessary or undesirable in the public interest. They can order any person who, in the opinion of the tribunal, may be affected by an order or award, or who the tribunal considered is just to be joined as a party to the proceedings on terms and conditions specified by the tribunal. They can hear and adjudicate any question which may arise in relation to a trade dispute in absence of any party. They can give directions and do all such things that are necessary or expedient to justify and fairly adjudicate matters. They can award interest at a rate that it thinks fit on the whole or part of any order or award. They can conduct its proceedings in a manner that it deems appropriate and just in accordance with the Industrial Relations Act. So the tribunal normally records its decision, whether orally or in writing, in a document signed by the chairman of the tribunal under Rule 11 of the Tribunal Rules. Under Section 62 and 63 of the Act, any order or award of the tribunal may be made retroactive from the date that the tribunal may determine as fair and just in the circumstances, and such order or award may be enforced by leave of the Supreme Court in the same manner as a judgment or order to the same effect. The Minister of Labor may apply to the tribunal for clarification or interpretation of an order or award on any particular issue under Section 63. The decision of the tribunal is final and should not be questioned in any court of law. However, a party may appeal and has a right of appeal of the decision on a point of law to the Court of Appeal on any of the following grounds. A, that the tribunal has no jurisdiction in the matter, but it shall not be competent for the Court of Appeal to entertain such a ground of appeal unless objection to the jurisdiction of the tribunal has been formally taken at some time during the progress of the matter before the making of an order or award. That the tribunal has exceeded its jurisdiction on the matter. That the order or award has been obtained by fraud. that any finding or decision of the tribunal in any matter is erroneous in a point of law, that the order or award of damages is inordinately high or inordinately low, that there are some other specific illegality not mentioned in paragraphs A to E and substantially affecting the merits of the matter has been committed in the course of the proceedings. So the Court of Appeal may make the following orders upon hearing of an appeal: to confirm, modify, or reverse the order or award appeal against it. If the Court of Appeal confirms the order or award appeal against, to order that there should be included in the sum which the subject of the appeal interest at the rate of 10% on the whole or any part of the sum. If it appears to the Court of Appeal that a new hearing should be held to set aside the order or award appeal against an order, and order that a new hearing be ordered, or to order a new hearing or any question without interfering with the finding or decision upon any other question. So Section 64(2) gives the Court of Appeal the power to make such final or other order as the circumstances may require. The Court of Appeal has the power to dismiss an appeal if it considers that no substantial miscarriage of justice has actually occurred, although it is of the opinion that any point raised in the appeal might have been in favor of the appellant. So let's go to Bahamas Customs and Immigration and Allied Workers Union and the Government of the Bahamas, the Public Service Commission, and the Attorney General. Who read that one?
I just go on, you say open Bahamas, we doing the immigration versus Bahama Public Service Commission?
Yes.
Okay, I just can't open it now.
Yeah, I started to read that one.
Yeah, I read it about the overtime,
Yes.
the flat rate.
Yes. What was the issue?
Well, when I say read, I mean loosely.
Yes. So the question,
I think the issue was whether it was a registered, whether they were registered to be able to argue that they can change the agreement to pay a flat rate rather than the overtime rate, the regular, it was a decrease in benefit. Something like that.
that was, yeah, the argument was about whether or not the Public Service Commission could change the way overtime rate was calculated. But the real issue when it came out to the Court of Appeal was whether the union itself, the BCIIA,
valid at the time.
were they valid at the time to act as a bargaining agent on the matter?
Yeah.
So the question comes in the same section we had just read earlier, whether or not they were recognized by the Minister of Labor as a bargaining agent for the custom officers. And the answer to that was no. Because you have to be recognized in order to act as a bargaining agent.
But you're saying it wasn't, but at number 5, it says that they were formed and formally recognized.
After.
Oh, that was after, okay.
After. That was after.
Oh, yeah, because this was in 2005 when the matter.
Mm-hmm.
Right. But just to stray a bit, Ms. Archer, it'll be interesting to see how this transportation thing is going to work out for customs too.
What transportation thing?
They had in the newspapers that all this money was paid, this bunch of what?
Oh, yes, I saw that.
Yes. For using their using their own vehicles or something?
Girls, yeah.
Yes. Some huge sums of money.
4 million to be exact.
Wow. Mhm.
Okay, let me see. That was 2 days ago.
Yes.
2 senior custom officers received a combination of $836,391 in reimbursements over a 3.5-year period by selecting themselves for the most lucrative import clearance assignments. Is that it?
Mhm. Yes. And the headline says customs officers paid 4 million for use of their own cars.
Okay, no.
Then
This
who
this
gave
was
them
one
the
is
license?
fee disparity. Let me see. Let me go back. I see. No, give me that heading. Give me that heading again.
It says customs officers paid 4 million for use of their own cars. And yes, the story starts off with the 2 senior officers received the combined 836,391. That's it. It's right at the top of that same that's the correct one.
That's the correct one.
Yes, ma'am.
Let's see.
Yeah, the heading says they were paid 4 million, and the story starts with the 836,391 for the 3 senior officers. Well, the 2 senior ones, yes.
Landon,
Oh.
where is this?
It's on Thursday's front page of the Tribune.
Thank you.
So let me see what they say. The Auditor General in a report tabled in the House of Assembly yesterday revealed that the supervisor in charge of Customs Examination Section and their assistant supervisor together accounted for 21% more than 1/5 of all so-called transportation fees.
Right.
These are paid to the department officers for using their own vehicles to attend the clearance of containers at an importer's premises. Finding that there was a vast disparity between the fee reimbursements obtained by different custom officers, the report said that the top 20 claims accounted for 61%, or 2.393 million of the total 3.913 million paid out between July 2018 and December 2021. That meant that the other 452 custom officers shared 1.52 million for an average of $3,363 per person, a sum which pales in comparison to that received by 2 senior officers.
Right.
Oh,
Yes. The 2 senior officers got all the money, while the rest of the officers got only 1 point.
Were they
Yeah,
actually people, were they even going out and actually doing what was alleged?
I
Were they
guess
even going?
I guess they'll find out during the investigation.
Goodness me.
But why would they have to use their own vehicles though?
I don't know.
When it comes to working in these government agencies. it
But
really-
those senior officers in the government employ have red plates and they get to use the government vehicles to do whatever it is they have to do.
Not
Yeah, they
everyone has
supposed to,
vehicles.
but not everybody is
Shortage of
getting it.
vehicles.
Well, I'm sure that their who's the highest person there have one they could borrow? Because I mean, if it's the government
No, you
vehicle.
don't borrow senior people cars.
No, you
Oh,
don't.
Government-
No,
I
but-
understand that, but then senior people say they're using theirs to do their business.
Okay, we have a number of cars, right? And any staff member can use them, providing they provide their insurance. We've all been asked to provide our our
Driver's license.
driver's license, yes,
Yeah.
so that they can put us on
as
the
a driver.
insurance.
Yeah.
Right, so that means that we use the corporation's vehicle when we are doing corporations work. So my question is, customs don't have any cars?
They have cars, but it's.
Exactly.
They're limited though. They're limited and there are a number of officers going out. So
Okay.
in the interest of that, they pay mileage.
Okay,
But his mileage is high.
For the two of them at 800 and what? Good Lord.
They was driving all day, every day.
No, they was
Weekends too.
driving to the family islands too, eh?
I think it leads to
weekends and
more
all, they
so
was doing
that they
drop
were
off
the
and
ones
pickups.
that were getting all of the inspections. The inspections weren't equally shared.
Okay,
I could-
it says here that we were informed that it is a practice for senior custom officers and grade 1 custom officers to manage the trusted traders on-site examination. So what are trusted traders?
I guess like
Super value and all the rest of
Supervalue
those.
and Kelly's and those, I guess, yeah.
Okay.
Look down like 4 paragraphs below
And
that.
the
It
Chinese-
looks like it's setting out what the expenditures are, and boy, they must have been doing like 1,000 of them a day to get that rate.
So the examination, okay, so it says here the examination section supervisor received $351,849 in transportation fees over the 3.5-year period, while their deputy took home some $484,000. That's a lot of money for gas.
Yes.
Hello.
They was pulling trailer, they was pulling the buildings themselves with those vehicles.
The
They didn't need
next
a
highest
salary
Tractor
earner,
on those vehicles.
the next highest earner received $190,619. The so-called top 20 fee earners were reimbursed sums ranging from $31,850 to $484,500. All this is paid from my money.
So
Yes.
it looked like it makes sense to go be a custom examiner.
But look,
All were assigned to the clearance of containers and other goods imported by so-called trusted traders. In contrast, the other 452 received reimbursements ranging from $31,177 to just $1.54.
Mm-hmm.
And they were the ones doing the work, I'm sure.
The auditors,
yes.
yeah, but they didn't have the top 20. The Auditor's General's office said the payment variance is significant with uneven distribution of attendance requests, resulting in inconsistencies. So who will be signing off on this money?
The control A.
And now we understand why she may be on the.
Yeah,
Now you see why they've added the VAT to our customs duties. You see that, right? They need that money.
they need the money.
Yep.
To drive around.
I'm still trying to understand why someone can't explain to me why I'm paying VAT on top of another tax. I don't understand that one, but anyway,
No,
now
but that
now
was,
I see why.
that was to pay them.
Yep.
This is the main reason for the 2 custom officers that supervised the examination section receiving $484,000 plus and $351,000 respectively. The records reflect that they assigned several trusted traders to themselves.
Ah, now you see.
Okay.
Now you
Oh,
see.
they had pure corruption and collusion.
But even when they do that, don't they get a kickback too? Because when they come, I'm
Yes,
sure
yes,
they
yes,
yes,
get
I'm
they
feedback.
sure
do.
they ain't get everything in order for them to pass, so they get a
Yes,
kickback.
they
Plus,
do.
they getting all that money.
Yes.
So when this comes up to court, you could be guaranteed that their trade union association is going to be high on the
Definitely.
defense for them. But you see the corruption and the wrong. Like,
Yes,
how can you defend that?
yes.
Yep.
But it's just that you'll see from when we do the one with Jennifer Brown. The only thing the union can do is just make sure the process is followed.
Right.
They have to give their evidence. They have to say how this came about, how they were given these trusted traders. Did they follow policies and procedures? And then you look at the policies and procedures that are in the industrial agreement in terms of them now being interrogated as to how they came to collect this sum of money.
Mm-hmm.
Because of the authority they had, they've actually gained the system where they personally benefited from the decisions they made about how trailers would be allocated.
Exactly.
Yeah, but they should not be assigning things to themselves.
Exactly. So it's personal gain that
Exactly.
their employment contract.
Mm-hmm. And that should not have happened. And
Yeah,
they should have
they
known
can-
better than that.
A perfect case for what? Summary dismissal?
But you know they're gonna argue all the way up to the Court of Appeal.
Yes.
They're going to argue. But the thing is now, they can't be like Sherry Brown.
Oh,
You can't be like her. Her story just was not adding up. Her story was not adding up at all.
But it just tells you how people are so confused, Ms. Oster, because if you know you're wrong, why would you go all the way to the to the appeals court to for people to hear how dishonest? How do you do that?
Because
I
you're
don't
wrong
know.
is strong. You're strong with your wrong, Lyndon.
Okay. All right. And then on top of that, your little couple dollars which you get when the court dismiss it, you have to pay those dollars out for paying permanent fees of their own part. But that's the correct one. That's the correct one. Yes, ma'am. Yeah, the heading says they were paid 4 million, and the story starts with 836,391 for the preceding officers of the two senior ones. It's on Thursday's front page of the Tribunal. Thank you. So, what is this? Article General and report supervisor in charge of customs and foundation section on the supervisor together. Accounted with 21% more than one or so more.
Yeah, that could be an interesting one.
Yeah.
Okay, so let's go to Sherry Brown.
Yeah. Let's see what's going on with her. It sounds like that's interesting.
Oh, there was a lot going on with Sherry Brown.
And BPL again? That's why I said this must be interesting because BPL seem to have all the good cases.
Yes, BPL. So she was at the tribunal first. Who wants to talk about Sherry Brown?
I'm just trying to scan through right now. I just got it this morning, so I'm trying to look through now.
I could take a tackle at it.
Yes, go ahead. You could start.
From what I recall. The case is, I think she was employed at BPL for about 24 years, and she worked in a restricted area. I think in the cash cage.
At the post office.
At the post office, and she would have been terminated for the policy was that visitors or outsiders weren't allowed in that restricted area. And the interesting part of the case was, I think she was saying that other persons in that area had also allowed people in that area. She had let this gentleman in the back, who she apparently was involved in some type of relationship with. He was an employee of the post office. And so she would have let him in the back, and they would have engaged in some lewd acts, and it was caught on camera.
What?
And so her argument was that I guess she wasn't the only person who had allowed persons in that area, and she should have been given the opportunity, I guess, for some grace because of her long years of service to the company. But I think the difference with her is that BPL's argument is it was more egregious because of her long years of service.
She should have known better.
She should have known better. But the other persons, they would have just let persons in the back there. One person, I think, discouraged, or they asked them to leave immediately. And then one or two persons, well, they didn't engage in those type of acts. So I think that's why hers was the most egregious. And then the big thing about it was that the disciplinary process was not followed. And even though the misconduct that she committed, she should have been given the opportunity to at least plead her case. Even no matter how slim her case would have been, the disciplinary process should have been followed. But I think at the tribunal level, they said that she was, because she contributed so severely to her dismissal, they would have awarded her unfair dismissal, but said that she was 90% responsible for her dismissal, even though the process was not followed. So they awarded her, she should have been awarded some $60-some thousand, but they took away 90% of her payment, and she only ended up with 60%, which, I mean, sorry, $6,000, 10% of whatever she was due.
Wow.
And yeah, so I think that was the case in a nutshell. And I guess, and she of course took it to the Court of Appeal. And I think I can remember that the Court of Appeal judge said something that he thought she was 99%, not 90% complicit. So she ended up taking it to the Court of Appeal, where she still was not successful.
No, she was not.
Of course not.
That, it was indicated as I'm reading this, because this just was like one of those
She went
you
there
don't want to
4
put down.
times. She did that 4 times.
Right, but I thought she was given opportunity to have her side aired. I hadn't gotten to the part yet about them not following the disciplinary procedure. But given how egregious this was, you are allowed to go straight, like not have to like do a warning and then do a formal written warning. You can go straight to let's hash this out.
Yeah, but I think that her argument was she didn't have a chance to explain. I don't know what her explanation would have been, but
I would have loved to know.
But yeah. I think what made it even worse is they played the video recording in court.
Oh yes, they did.
And
that was because she said that he just came in.
He just came in, but based on the description of the description of the video, it was very much out there.
Yes, her raising her gown, and they say they think that sexual things were carrying on.
And then also other employees were in the presence, so that made it worse.
Hold on, wait, what?
He couldn't wait to go home. I mean, really?
So her argument or her defense actually was BPL's defense. That she said she should have been given an opportunity. This was her first breach. She had not been, she's never a problematic employee. She was a high performer or whatever it was. And they said, this is why we expect more from you.
Of course.
And it just begs the question that this wasn't the first time. This is the first time they caught it. But you don't have this kind of behavior just out of the blue. Mr. Ferguson really was something.
Reading it said they caught the video footage on 4 separate days.
14.
Yes. Yeah.
Yeah, it said it was 4 separate days. So she really expected a union to fight for her with this?
Really?
Yes.
Oh,
what? Look at the top of page 12, paragraph 27. Like that. Just reading that, it's like
page 12.
Yeah. Paragraph 27. Number
no
12.
Paragraph.
Bending over and oh my Lord.
And she wanted a union to defend her with that?
That's right. I would have been so embarrassed. The video, see, it's one thing to have people saying that, but then the video was like
very explicit.
The nail in the coffin.
Oh boy.
You mean spreading her legs and lifting her dress?
That's right.
Exposing her private parts.
And that's not even the policy part of it, that he was a non-employee in a restricted area.
But don't forget now, other people are coming.
And I think that's it right there. I think that's it right there. Anytime you get in trouble, why are you bringing up other people's problems? You're the one that got caught. This is your problem now. Why are you worried about what other people did?
She don't go down by herself.
No, but as a 24-year employee, she should know whether other persons did it or not. It was wrong.
Exactly.
Yeah.
So she should be held accountable.
You know what I thought was an interesting point too. I mean, not for her case, but I mean, you could also, as an employer, one of the arguments was that if the employee or the appellant could prove where similar acts had been committed. I mean, not in her case, but I'm just saying you could use the argument if you can prove that similar acts have been committed and they were not penalized as severely as she was, she may have had a case if BPL was aware that certain acts were committed and they chose not to, I guess, investigate them or deal with them. An employer does not have a right to say that when they're going to enforce a particular policy. You can't say, okay, I'm follow the rules in this case, but I'm not going to follow it in that case. So, but she did not prove that this had, because I'm sure in the workplace you have persons who engage in, well, maybe not on the job, but they engage in these type of, I guess, similar, hopefully not as egregious. But if she could have proved that she was aware that persons had were involved in those type of acts, she may have had a little bit of a case, because an employer can't just decide when they want to enforce their own policies, because then it could be looked at as, discriminatory or whatever. So I thought that was an interesting point.
The acts could have been, it's just that her area was an area where unauthorized person should not have been.
Yeah.
That may have been the issue that was damning for her, not the fact that the sexual or lewd acts were being recorded. Because I'm sure, like you say, in some other office, someone else has done something that was probably captured. But this is because this is in the cash gauge area.
Yeah, but I think ultimately what cost her a case was the lewd act. It was not the restricted access, because like she said,
people were there before,
similar persons had they were only suspended for a certain period. What took her case over the edge is because of the acts that she committed. It wasn't so much the restricted access.
And years of service.
And years of service, yeah.
So to some point, she was given a blight until the video started to
yeah, well, I don't think she would have been terminated if the person had just come in there. Right. Yeah, it was so much. It was more the act.
Yeah, she would have been just suspended.
She would have just been suspended. So
he was going away. They couldn't wait till they got home. What was going on?
I don't know.
It belongs to someone belongs to someone else.
But that's Sherry's part. So what happened to the gentleman's part from the post office? From the post office view, what happened to him on that side?
But I would have loved to know that they didn't even listen. There was no reason for them to interview him. I mean, the facts were there. I mean, I see why they did. They probably say, we don't even have to question you. It's not a matter if you did it. It's there.
And remember, it didn't happen on his job.
And
it happened on her job.
No, but he was an employee of the post office.
He was a post office employee as well.
Yeah, but he was a BPL
employee.
He was not an employee of BPL. So I don't know, maybe if you search, we don't know what ended up happening to him, but they really didn't mention. I mean, they did call his name.
Nothing. He's a government employee. Probably.
They did call his name.
Let it just move him somewhere else.
Yeah.
No, but that act did not take place in the post office proper. It took place in BPL space. Yes.
So once he ended that Cash's case, that was on this jurisdiction.
Oh yeah, that was
and then it was a shared cashier's cage. I think they shared it with NIB.
Oh my goodness.
Oh, really?
Yes.
The risk,
a little small at the post office.
Yeah. And then you could pay your contributions there and pay your light bill.
Well, Sherry, all I can say is Sherry was really brave. That's all.
Sherry had many guts and glory. Apparently, Mr. Ferguson was irresistible too. So I don't know.
Wow.
So let's look at why the Court of Appeal heard her matter. If you turn to page 15, that'll be paragraph 9. But page 15, they say, coming down to the final analysis, Ms. Brown was not given the chance to say why she should not be dismissed before the decision was made. This is where BPL made the error. Don't forget now, in the industrial agreement, you have a process.
Yes.
And you have to follow that process to the T.
I guess they were saying, Ms. Archer, it wasn't nothing she could possibly say.
Hey, that's right.
Unless he was her doctor and he should have an office. I mean, it was nothing she could possibly say.
But you have to follow. Followed. Yes.
Yes. So if she had been given that chance, there is based on an assessment of the case she presented, a single point in mitigation she could have advanced. Don't forget now, in the whole process, when you're going through this, you have to talk about mitigation. How can you mitigate against this?
I don't see.
And her mitigation would have been, out of all the points, her long service. It couldn't be following policies and procedures that she
But the long
violated that.
service alone should tell you.
Because of your long service, your expectations were
You should
higher.
know better.
Exactly,
Right.
your expectations.
So on her side, she could have said because of her long service, she's been there, they should take some of that into consideration. But what the employer did on the flip side was, because of your long service,
You
we
should
no
know
longer
better.
trust you. We don't
You
trust
should
you.
know better.
And then to Miss Archer, I'm not sure if it was in this particular case that I read, but I think the judge said something to the fact that, listen, if you had, they give points for when you come in apologizing, you come in show it at the mercy of your employer, but you didn't do that. You came automatically with a defense. Normally, if you come in with, listen, have some mercy on me, I admit my wrong. I know I did this. I know I did it. Then we could see that, okay, this person may have, there's something we could consider, but that is not something that you didn't even come from that. You just came that you're entitled because of you've been there for so long, So I think that really didn't help her case at all.
I think she was just shamed, man. She was shamed.
And they
No,
said,
I don't think
No,
she
she was
shamed.
not.
I think she
If she
No,
was
she
shamed,
wanted
they would
them
never
to
go to
prove it.
court.
I
Yeah.
think she was
and did they say that it should have been 99%? I saw something that said, you're lucky you got the it was only 90% taken away.
That's
should have been
but I'm
99.
surprised they gave her anything.
Well, maybe if she did
That goes
apologize,
to show how important the process is. Following the
A
process.
summary
Yes.
dismissal right from my
You
name.
have to
Really.
follow. You have to follow.
Then you have to follow the process.
Right.
Yeah, and I'm familiar with one of the other cases that they cited, where an employer would have lost because they did not follow the process and nothing was deducted. But that case was not an egregious offense. It wasn't as egregious as that. But just because they did not follow that process, it was considered unfair. So no matter how bad it is, you still have to follow the process, even if your mind is already made up as the employer.
But isn't that a case for summary dismissal?
It is, but it doesn't. The fact that you don't allow the employee to go through the entire process as you outlined,
right.
disciplinary should happen, is why you would fail on having not followed the process.
You have to follow the process.
Is, yeah.
Okay.
You can't have a policy and a procedure that's only one-sided, that you can determine, decide when you want to follow it, but it works both ways.
Well, they didn't lose much, so they all right.
And I think
so?
I think they awarded her. She was
No, I'm talking
responsible for
about
the cost.
BPL.
No, but I think she was responsible for cost. So I need to look at the bottom. I can't remember if she was responsible for
Let me
paying
see.
their cost.
I'm
But
saying
I'm
BPL
sure it was more.
didn't lose much.
It's
It's
in no
BPL.
order, yeah. At the Court of Appeal, they said no matter was made for cost. And at the tribunal, let me see. They didn't say.
Oh, okay.
Who the
See,
one
let
she
me tell
probably
you.
would pay?
Yeah, but see, listen, let me tell you where she went wrong. In her second meeting, this is in the tribunal, page 12, page 13, paragraph 34. In the second meeting, which took place after Ms. Brown's interview with Mr. Strawn, Ms. Brown with Ms. Bodie met with Ms. Johnson and Mr. Rutherford. In this meeting, Ms. Brown was informed that she was being suspended for 5 days pending an investigation into gross misconduct. She was then given a letter to that effect. So as it turned out, Ms. Brown got particulars of the gross misconduct in her interview before she got the letter, stating that this was the matter being investigated. She was told in the meeting that if she was found culpable of the matters being investigated, she would be subjected to further disciplinary measures. But if she was exonerated, all monies, namely the 50% salary docked during suspension, would be returned and a letter would be placed on her dossier to that effect. Ms. Johnson asked Ms. Brown if she had any questions or wanted to say anything. Ms. Brown responded that she did not. Neither Ms. Brown nor Ms. Bodie sought clarifications on allegations against her or asked what the matters were of which she might be found culpable. She refused to ask questions because she knew.
Okay then.
In the third meeting, Ms. Johnson met with Ms. Brown and Ms. Bodie to advise Ms. Brown that the investigation was not completed, so BPL would be extending her suspension pending investigation for 10 days. Ms. Johnson gave Ms. Brown a written notification to that effect in accordance with the industrial agreement, a copy of which she asked Ms. Brown to sign. Ms. Johnson then asked Ms. Brown if she had anything she wished to ask or whether she wanted to say anything. Ms. Brown then questioned why she was being suspended for 15 days. She said she knew Mr. Ferguson was in the cashier's cage and that she hugged him. But 15 days? Then she said, but 15 days? Like, why is BPL suspending you 15 days just for hugging a man? So it appears to me like if she didn't know that a camera was there.
But you have to know you're dealing with people, money everywhere. Money's being dealt with. There is a camera.
Somewhere else in the pleadings as well, that the comment after she said she only hugged Fergie, it was you did more than hug him, and she made no comment after that.
Yeah.
Really, come on. And even better, the camera was there or not. You on your job. Come on, man. And 24 years later.
Yeah, exactly.
And the thing about it, they said, I think this is a mature woman. This isn't like a, obviously
But she worked for 24 years.
Yeah.
She, you know,
she should know better.
So even if she was 18 at the time and I had 24 years, she's no spring chicken.
Right?
No.
She couldn't been that. No way.
See,
it's sure she feel a union. Get her down.
So she said Miss Johnson's comment that Miss Brown knew she did way more than hug Ferguson exercised the mind of Miss Brown. Her evidence was that the next day she remembered she lifted her skirt. Having come to this realization, Ms. Brown never reported this detail to her employer. The investigation was still open at that point. In fact, Ms. Brown had 2 weeks within which she could have approached BPL to disclose what she knew she had done. Instead, her evidence was that she took advice about this recollection of her lifting her skirt from Jennifer Isaac Dotson. So she showed no remorse, none whatsoever.
Oh my God. Oh Lord.
All them years going down the drain.
That's right.
Your reputation.
I wonder if her and Fergie still together today.
Fergie ran. You know Fergie ran.
Of course. Of course.
For the mere fact that they didn't even mention him.
That's why it said, I wonder what happened.
Oh, wow.
We need to find out what happened to Mr. Ferguson.
Why?
Like it would normally
something
happens to the man in the case.
Nothing.
Nothing.
Nothing happens to the man.
Well, he
Never
was,
does.
he was on her job. If she didn't take her job, she wasn't on his turf. He might have been on his 15-minute break. Out to lunch. He was enacting in his capacity.
Wow.
He owed nothing to BPL.
No. See, every time they asked her, she didn't have anything to say. She would not admit what she did in the cage.
Nope.
But Miss Archer, if this was taken to her union reps, I don't see anything mentioning them in it. Well, from browsing through, but didn't they advise it better?
She probably didn't want that to be disclosed. She may have been a married woman.
Well, everything is disclosed in the case because look what it did.
Yeah. Don't forget that BPL, after BPL let her go, she should have just left that like that, but she wanted more money.
I'm serious.
I can't understand how when you know what you did.
I'm sure her heart must have dropped when they played that video. When they played that video in that courtroom, I know her heart must have dropped.
They say she admitted only to some of her activities with Mr. Ferguson, which were not of a sexual nature, but yet inappropriate and or prohibited according to BPL's policies. There was an invitation extended by Mr. Strawn for Ms. Brown to say anything at all which she wished to say. She could have further responded to the issues put to her. She could have disclosed the truth about her conduct with Mr. Ferguson after he accessed the cashier's cage, or she could have asked questions if she had any doubts about the allegations being put to her. She wanted to hide it until they actually presented the recording.
Deny until you show.
That's right. She's probably saying in her mind, prove it.
Hey, right, that's right.
There was no camera, it'd have been her words against theirs.
Exactly.
I have a question. This is a little off, but in regards to cameras, can an employer put cameras in a room or whatever without the employees informing them? Because I'm trying to figure out how is it she, after all these years, did not know or did not see a camera.
But that's a cashier's cage. She should know cameras are there. Everywhere that has a cashier cage has cameras.
Right over the drawer, that's right. And everywhere else.
Miss Archer, that's what's expected, because if we go and check a lot of these things, we expect that to be, and you may even have dummy cameras up just to scare people. So, I mean, I guess the expectation of, because it's a cashier's cage, the camera should be there, versus the camera's there, you didn't advise me or inform me that it was there.
When an employer uses cameras, it has to be made known to the employees.
Right.
But not necessarily every camera.
But it's not hidden, is it?
No.
They didn't say a hidden camera. They didn't say a hidden camera.
Hold on, they did say something.
Somewhere I've read that in the Bahamas, I don't think you can put hidden cameras in. That if you
no, you can't put hidden.
Right.
So she had to have known the camera was there, because that's not a hidden thing.
Right.
So she can't use that.
So they probably put it up. They probably put it up over the weekend, and on Monday when Fergie came, they didn't tell her time, so she didn't remember, because they did it on the weekend.
Hold on. They said that the cameras were positioned in and outside of the cashier's cage. They had lots of cameras.
Yep.
Okay.
And that would have had to have been made known to the employees. And she just chose to remember.
Maybe she thought the angle they were at, they wouldn't be able to see. Probably was the angle.
I was going to his job every day. Every day I was going to pull up by his job every day.
Wide lens.
Yeah, that's what probably happened. They looked at it and they probably thought it was just like focus on the cash register.
Or whatever, yeah.
Yeah, not knowing that it was wide.
Okay.
Wow.
Why you laugh?
Because it's hilarious.
This is not hilarious. This is disgraceful.
Yeah, I think it's disgraceful.
4 days.
Happened to her, no way.
4 days.
Okay, it says here, while the applicant and Mr. Ferguson may or may not have had romantic feelings towards each other, their activities as described in the transcript, recorded electronically, and as described by Ms. Brown in her witness statements were clearly of a sexual nature.
Child, if they didn't have romantic feelings, I wouldn't like to see if they did.
Oh my gosh.
Basically, the footage showed that Ms. Brown on 2 occasions opened the cage door for Mr. Ferguson, and on 2 occasions escorted him into the restricted area. On 3 occasions, Mr. Ferguson accessed the cashier's cage as the door was either left open or unlocked by other workers. Based on the camera footage, Mr. Ferguson's main reason for visiting the cage was to find Ms. Brown for the purposes of chatting closely, groping, kissing, touching intimate parts of the body. And Ms. Brown exposed private areas of her body. Ms. Brown's witness statement mentioned she performed similar acts.
But going through an open door because it opened, that makes it right again. But then we said, we don't know what happened to Fergie on the next side.
No.
No, but Ms. Brown had a right to BPL to make sure that their rules and regulations were followed. So even if you see that the door was open, you should have done what? Because a robber could have come in.
Mm-hmm. So she was
But it didn't say
expecting him.
her. It say other employees may have left it open and he just took the liberty and gone in, I guess, because he used to doing that.
Now, don't forget now how it was situated when you walk into the post office. That little window was to the right, and then all the rest of the post office people would be behind the custom officer. So all she had to do was give him a wink, door open. He run over.
And he was.
Lyndon, you. Okay, it says here, perhaps the most risk or egregious of Ms. Brown's public acts were bending over, spreading her legs, and lifting her dress, thereby exposing private areas of her body to Mr. Ferguson, but also in the presence of her work colleagues.
She's gotten moving.
The tribunal cannot find it unfair that BPL considered this to be unacceptably lewd, surpassing mere unprofessional behavior. Additionally, it would not have been unfair to say that the other acts Ms. Brown and Mr. Ferguson performed, as were recorded, intimate touching and kissing, for example, were inappropriate in the workplace. In the context of the workplace, even if her activities with Mr. Ferguson were not done in view or in proximity of BPL and co-workers, Ms. Brown may still have been subject to a gross misconduct accusation. There have been cases where acts of a sexual nature, which were not performed in full view of workers and done after business hours in a darkened office space, have been found to be gross misconduct and a dismissal of the employees involved not unfair. And they gave you a case of GM Packing. So her behavior was one of an indecorous sexual nature, performed in such a way that it was fully observed and based on the demeanor of BPL's witnesses, offensive to the employer, as well as having the potential to be offensive and demoralizing to co-workers on BPL's premises. The tribunal could find no unfairness in how BPL characterized those acts perpetrated on its premises. So appeal was really only on just the procedure.
Wow.
That was it. That's Miss Sherry Jennifer Brown.
But see, that's just
All her name.
That's
All
a
her
good
name.
All her
Serious
name.
man.
of how the union should have advised her that she honestly did not have a case, regardless of whether she had a final option to explain her behavior. The behavior she was trying to explain was egregious and outrageous.
Yes.
They should have guided her. Don't push this. Accept your punishment and move on.
That's why I had asked initially, Catherine, what was her advice from them? And that's why I say, even going through this, I don't see much things coming from them.
Which begs the question, what are they there for?
But then you can't take up a case unless someone brings it to you. So if she didn't go to them with it, they can't take it upon themselves to go and say, let me do it.
Agreed. So even if she
Yeah.
brought it to them when they found out what the facts were, their advice to her should have been, this is not one you're going to win.
But who's to say they didn't tell her that? You know, some of us, we think we right, like Kendra said, wrong and strong.
Wrong and
strong and
strong.
wrong.
Wrong and strong.
Mm-hmm.
But I'm
I'm
almost
looking
certain
now. Let
you
me
didn't even
see.
have to be a part of the union to go to her and say, Miss, slow your roll. Like Felicia said initially, if you're gonna actually go and fight this, go in there humble. First, you go in there admitting you're wrong.
Yeah.
And then sell them some BS story, but you was heated, you was hot, and your boy was going away or something. Try work
That
on
wouldn't
you.
have, that would not have fly.
Try work on the human side of them. But don't come and saying it wasn't me, I ain't do nothing. Because then
She
now you're
couldn't win that.
making me think I fool. So now you just get more irate.
There was that's totally, that's a case of just leave it, just go about your business. You can't explain that away.
Give me what you got for me and let me go.
Yeah, I don't remember saying much in here on the union,
Right.
but
That's
I'm
why I was
sure
saying,
she
I
went
didn't
to the
see-
union.
That's what I was saying initially, Ms. Archer. I didn't see much about union representation. I see she spoke a lot about Jennifer Isaac Dotson, but I don't know what was her role in all of that.
But
Yeah,
if
but
the union told her,
Go
But
ahead.
then she would have been like the other two people from BPN who said the union wasn't making sense. Trevon and Deonya and whatever the next one was. She'd be like them, say they wasn't making no sense, so they could take it on themselves.
Yeah, there's not much here for the union. No. They didn't say that she was a member.
okay.
That was it.
On page, what is this? On page 2, it says that she was fully appraised of the allegations and had the opportunity to respond to the assistance of her union representative. So at some point they were there with her.
Mm-hmm.
But they saw that was a lost cause, so.
Yeah, especially when they saw the video or heard of
They
the
might
video.
not have seen the video at that point. They might have only
Yeah,
heard
they
the
may have heard of
allegation.
it.
Yeah.
They may have heard of it. But I don't see why would she push this far knowing that there were
Knowing.
cameras.
Exactly. Well, it's just not even the cameras, knowing what she did. Why would she push it?
Mm-hmm.
Because if you could do it and no one catch you, and you say it wasn't true, you get away with it.
Wrong and strong, like you say, Kendra. Wrong and
Right.
strong.
Mm-hmm.
So I guess, Ms. I think she had to not know but them cameras. She think the angle was off.
Listen,
most likely.
You know what I think is that a lot of times employees only look at reasons they could be terminated as theft and or fighting and cursing, those
And
type of things.
insubordination, yeah.
Insubordination. That's
yeah.
the only things they really look at. So anytime they commit another breach, they look at, okay, well, there's something small. They don't look at the serious. They don't understand the seriousness of it. And so that's why she didn't come in at the mercy of them. She was like, why they can't overlook this? I just kissing or this is my boyfriend or whatever it is. She did, in her mind, she was not receiving this as a serious offense. So that is why I think she took it to that extent. She didn't see the big deal of it because in an employee's mind, they say, oh, well, I mean, why would they let me go? I've been here for 24 years. Why they couldn't just suspend me or just give me some other punishment, but to let me go over, I just get a little feel up on the like, money gone missing, I mean, that's what I'm thinking. From her point of view, she didn't.
She didn't read that little blue book from the union then.
They overlook.
Exactly.
They overlook.
Or she didn't read her policies.
Offenses.
She didn't read her employment policies and procedures.
Yeah, they overlook a lot. They don't measure them the same. Breaches the same. Always to the top of the list. Hey, money missing. This. She was like, it's only a little. What's the problem? And that's why she didn't go in there humbly apologizing, because from her point of view, I think she is thinking, why couldn't they give me another chance? She still doesn't take responsibility or ownership for her part.
And I think that another point too is her lack of respect. Even if she didn't respect her employer and his place of the space that he provided for her to work, her disrespect for her fellow employees who couldn't have been that big an office or space that they were in to conduct
It's very small
activities like that within earshot and possibly eyeshot of fellow colleagues. It's just like that's just mind-blowing that you think that's okay. And what about their right to work in an environment that is
14. What's the next size?
But what if they're the same employees who she was referring to who did it before too and never got caught?
Oh, hello.
Two wrongs don't make a right.
Oh,
exactly.
Yeah.
Open up my phone.
She got caught.
Yeah, what were you saying?
11 by 17.
Mm-hmm.
You get a lot of feedback.
Yes, 11 by 17.
Hi, Miss Smith.
And then you get 18 by 24 or 24 by 36.
Hello.
Okay, hold on a second. Let me grab my pen.
Hi, Miss Smith. Hello.
She can't hear. Okay, just like Catherine was saying, it said she had during the investigation the benefit of union representation and legal advice.
Mm-hmm.
And she was
wow.
given a recess to consider her position before continuing her interview with Mr. Strawn. And before the meeting in
Okay,
which
11 by
BPL,
17 is how much?
she don't know she's not on mute.
I'm serious.
So before the meeting in which BPL dismissed her, she was informed by the union representative that BPL decided to dismiss her, but the representative was arranging for her to resign instead. She
Which
took
would have been
advice from
more.
her, right, but she took advice from her lawyer, Obi Ferguson.
Oh, Jesus.
What?
Oh, Jesus.
She took
Another
advice
man.
from her lawyer before the meeting in which she was dismissed.
Oh.
Now she have to go back at him. What could he have possibly said to her other than?
Yes, ma'am.
Other than we have.
Okay, and give me the next size up because I want to write this down.
I don't think Mr. Ferguson or OB, I don't think he turns down any
Okay, what time do you
cases.
close today? 2 p.m. Okay, thank you, hon. And you, Monday to Friday is 9 to 5?
Look here, she doing her personal business on our class time. She's not even
Hello?
listening.
That's what I'm saying.
Oh my goodness.
That's another brave soul.
You see?
She brave, bro. That's another brave soul.
Okay, she finished with that now. She's back.
And now she mute?
Wow.
She realized.
Wow.
This Sherry Brown heading good because the company offered you an option to
Yeah, the union told her she should resign.
right, and you rather than listen to what the union said, that's why there was no mention of it too much in here because they already
Yeah.
advised her.
But Obi Ferguson tell her, fight.
Okay.
He didn't have.
I
he
can
didn't
remember
keep-
that name. You all remember
was-
that name. You ever need a lawyer?
How you can forget him? He's the
That
TUC.
name is
He's the TUC president.
notorious.
Right, he's the TUC
Notorious
president.
in labor
Forget him.
disputes.
That's what he does.
Oh, you know why?
Because he's gonna be paid. He's gonna be
Oh, my
paid regardless
Lord.
whether she wins or not.
Oh,
We
Lord.
had him in the case last week too, remember?
Yes, I remember that. Yeah.
Okay.
His name is in most of these cases.
Several, yes.
I know.
Because that's what he's a trade unionist. That's what he do.
No, but you should know that. So that's all about the money.
Well, he's one of those, Lyndon, that you spoke about.
Yes.
That's why initially when I said if the unions can't come together because one person won't be the biggest head, if they can't come together, then the unions can't be taken serious. If it's going to always be a divide.
A private matter between her and BPL has now become public knowledge because her case is one of those. That was okay.
I just hope she know Mr. Ferguson were married because their names are forever etched.
Yes.
Yes.
Oh, but notice Mr. Ferguson never gave a statement, so he was out of it completely.
But I just said he was not on. He was not on
Ferguson.
Nothing happened to him. It was not him who worked for BPL. She did.
No.
But shouldn't they find trespassing or something against him? Because even like you said, Ms. Archer, if she left the door open and she gnawed her head, he wriggled, okay, the door open and you walk in there, that's trespassing, isn't it not?
No, an employee let her in.
Yeah, she let him in.
But then the door was left, at somewhere it said the door was left open. So at some point it was left open. He just slide in.
Because she probably told whoever to leave it open.
And that's right there when I would have said not me, but it was not me, not that day. Maybe another day, but not this day.
It didn't matter. It was done. It was done.
Some of them days when I had to get knocked down. They would have been able to say 2 days, but they wasn't to say 4.
But I'm wondering what kind of relationship they had, because if I'm going to see you when I get off, why would I have you at my office doing something like that?
Because one of us is going home to someone else.
Yes, exactly.
Wow. Yeah, well, make sure none of them get no one else know.
I think that point raised about trespassing may be a valid one against Fergie, because I'm sure they would have had signs that that's a restricted area.
And
Yeah.
employees only, employees only.
Employees only. Yeah, employees only.
But he was allowed, the
But he
employee
can
reached
read
and
in,
let him
though.
in.
But he could read and he should, they, well, who knows? We might
He was
read about
blinded.
this in a little
He was
while.
blinded.
By the raising of.
The raising of the skirt. He was blinded.
Oh my gosh.
Yes, he
Okay.
was blinded. All right. So the last section is on industrial actions. I think we had industrial actions, was it last week with NIB?
Yes.
Mm-hmm.
See a lot of them, we've seen a lot of them recently.
Oh, as a matter of fact, in the paper this week, I think it's about 3 different places have sick-outs.
Sick-outs, walkout, yeah.
NIB, I think had something, yeah.
Late lunch, days of, yeah, they have all kind of stuff. And a lot of it's look like that, and that seemed to now be the prominent. That's the only way the union seem to be able to get notice.
But I think the pandemic is causing all of this.
Why?
Because it's opened your eyes to a lot of things.
Because the employers are now, like I was telling you with my nephew's case, maybe some persons were laid off, and now the persons who are staying are the ones going to be asked to do the jobs of those who are. Oh, and so if I am not, if that's not my job, you let the person go. Why now ask me to do it? You're not compensating me, so of course I'm going to go to the union, or of course I'm going to call in sick, or I'm going to react to what you've done to me. So I think the pandemic is causing a lot, because now the employees have the cutback. I mean, the employers have the cutback, and like I'm asked to do something. The corporation is gonna compensate me for it. So maybe that's not the case in some of these places, because if it was, we wouldn't hear about it.
But then, like you said too, Lyndon, I think the pandemic has opened a lot of eyes to shifts and things that are actually possible, because you have a lot of employers who only want people around to ease their own ego. I just want to know that I'm their manager and I can see you and I want to be over you. Versus you can be home and you can work from home. Because I think the work from home is going to kick into a lot of issues too soon.
Yeah, but we easing up now on the restrictions. So work from home means coming back to work. Now, right.
Full time.
Full time. But employers have to look to see whether or not it's cost effective for all of those persons to come back.
But weren't they there before the pandemic?
Yeah, but then you have to make certain, you have to fix certain things now. You have to make certain amendments to your structure to accommodate those things.
Because a lot of employers are now deciding that, guess what? They see that the working from home is more cost effective for them.
Right. But that's why I said the pandemic is creating some situations and it's affecting some workers. And so I don't like it. So I'm going to go and report you to my union. Okay.
But you see with the pandemic and the changes, a lot of the way in which we did business for certain companies have changed.
Yep.
And they realized in some instances it's for the better. And then there are other instances, because of the pandemic, they had to let go a lot of people, and they are stuck in this mold that, guess what? I lost $300,000 or $500,000 during this last 2.5 years, and I'm getting that back.
Right.
And so they have no intentions of hiring more people.
Yes.
None.
And
just
so
work who you have and drag
work harder.
So you have to work harder, work longer hours.
With no compensation.
No, you're not going to get more compensation because they want more bottom line.
Correct. And that's why I was telling you that had to be a situation with my nephew, because if you already have someone who cleans the outside and you're now asking me to do it, where's the person who was cleaning the outside?
They're gone and they're not replacing them.
Right. And I'm not adding anything that's now going to become a part of your job description.
Right. And so in many instances, that's what they're looking at now. Yes, they would have had 5 people doing a particular function. They'll spread that over the existing person's job description. That's what they're doing.
Right.
Because they have to make up for the monies that they lost.
Yes.
So yes, the whole workforce dynamics will change. So as they're trying to adjust to COVID or the pandemic, and the way in which work was being done remotely, some part remote. I think some employers still doing part remote, part in office. Where people come into the office 2 or 3 days of the week and then do remote. Now comes the part now, right? Now comes the part now with the war. What do you do in the event that there is one?
Right.
Your business continuity plan needs to address what if. Because you can't wait until that happens and say, everybody run home. Then people say, oh, but hold on. I returned my computer. I returned my laptop. So how am I going to work? What hours am I going to work? Who has access to what? And that's what COVID should have taught all of these employers, how you can shift from working in office 5 days a week to either working 3, working 2, or full working from home.
Well, I haven't worked remotely or from at home since the pandemic.
Okay,
we've had other persons. We have our accounts department, for instance, has worked from home, but the rest of us, we had to go in because some of us are customer facing. My department works with inputting data, but we have to use the files, and I guess they don't want us taking the files from the office. So who knows?
Yeah, but all of this the employer has to look at. And like I say, everything is the bottom line. How whatever amount of money that they have estimated they have lost, that's what they want. So in industrial action, you can have a walkout, a strike, a work to rule, a sick out. And we've seen a lot of sick out. I think in February, the finance officers sick out, the Tribune reported may affect staff payouts. The government had estimated 7.5 million in revenue after finance and accounting officers throughout the public service withdrew their services from Monday to Friday in what the Ministry of Finance has called an illegal coordinated sick out. The impact of this action on the delivery of services was severe. No payments to vendors or employees were processed, and more importantly, the accounting and collection of revenue were impacted. The estimated financial impact of this coordinated sick out to the government was $7.5 million due to revenue loss or foregone and lost efficiency. So you see, when you have a sick out, it's not just you fighting for your rights, but you have to look at it from the employer standpoint. How are they going to now get this money back? So that's why my view is always unions are good and unions are bad.
In talking with our finance officer, it sounds as if government is planning on taking it from them.
Well, you've lost money.
Yes, ma'am.
Yeah, you've lost. The Ministry of Finance said no group of employees should hold the entire public service hostage. And that's why certain areas are classified as essential services. You just can't halt a country. Because think about it logically. If we're at the stage now where we need revenue, people are coming to pay and they can't because you're on a strike. Anyone know what the strike was about?
No.
Fair promotions and owed money.
But the thing is, Ms. Archer, the only way you will learn, the only way you're going to respect or understand what I do in my pain is if I make you see it from my perspective.
But in the long run, if the employee is not receiving any money, then how are you going to get paid?
From the stash and everything else they have and all the other outstanding payments they got.
It don't work that way. It don't work that way.
I understand that, but it's I don't know. I guess trying to get people to see your perspective or walk a second in your shoe, I think we have to find a way to ensure that that happens without causing so much damage.
Yeah, because that's what you have to look at. If the government loses that amount of, yeah, but see,
you'd never understand. You'd never understand if I'm sitting down trying to write this book, you would never understand what it takes for me to write this book until you now sit down and try to write a book yourself. And then you realize the value of what I was doing for you all that time. And I think that's where we lose, that's where a lot of employers lose the empathy for their employees. And so the only way now for you to get my point is for me to bring it home to you.
I think the start of any union in order to make demands is the respect
Yes.
for that union representative. I don't think you need to go to this point, what they did, in order to be heard. If the persons who represent this union is respected, then talks begin at the table. Because this is a coordinated thing where all of the persons across the whole public service. So it was coordinated, but look at the loss of revenue, 7.5 million, but you're arguing for more money and you're arguing for promotion. As an employer, it makes no sense to me. You're hurting yourself. Because did they get the promotion?
Not as yet.
Not as
No,
yet,
but-
okay.
But were they able to at least open someone's eye to see, we have to revisit this or we have to look at it?
I have not heard nothing.
Wow.
Okay.
Sacha,
Yes.
you remember I spoke to you about that 6% cost of living increase we were supposed to get this year, right?
Yes.
And how my human resource director was saying, oh, that was only if the cost of living went up. I think she said 3% within the last 3 years or something to that effect. But since I had conversation with her, and I think I told you that about 2 weeks ago, we've had about 6 new employees. So you're trying to tell me you're only going to give us this if living has gone up, but you're hiring persons every other day and trying to find a way not to give us who are already there 6% increase based on the industrial agreement that we signed.
So the new people are replacing persons who passed away?
No.
New area?
No.
What's the rationale for it?
We're trying to figure that out because recently we've had one just this week hired into our Freeport office. And we're all trying to figure out why, because number one, Freeport has a high unemployment rate. They're coming out of a damaging, destroying, you call it devastating hurricane. So we're not getting much business from there. So why would we need to have an employee in that office? And we already have, I think we already have 8 or 10.
But that's a good question to ask management. Why are you hiring?
No, I'm not going to ask her that. I only want to see my 6% because, they have this thing. They don't have to explain anything to you. And of course, if you ask them, they're not going to be honest. They're going to find some bogus reason to give you anyway.
Yeah, they're an employer. But the thing is that if you hire more people, then that cut in the chances of you getting 6%. So you really need to find,
I can tell you when I get it. I can tell you when I get it because guess what? Like we were talking earlier, but when these agreements expire and stuff, that agreement that we're under for the 6% is in effect up until October of this year. So that's not going to be my problem if they don't have money to pay because we've already have an industrial agreement signed that says I'm entitled to it.
Yeah, so then they'll have to pay.
They'll have to pay.
Is there any caveat in it anywhere?
No.
Unless? Nowhere in industrial agreement.
I didn't hear that part. You cut off for a moment.
Oh, I would say, is there anywhere in industrial agreement where there's a caveat which says unless certain things?
No, it didn't say that, but that's what she was trying to tell me. So I wanted to make sure I went back and I looked at the agreement. It doesn't say if the cost of living goes up 3%, and it doesn't have any restrictions, any conditions assigned to that. It says we will get 6% cost of living increase, and everybody knows that in the last 3 years the cost.
Hold on, you cut off.
You can hear me now?
I can hear you now.
Okay, I was saying everybody knows it's a moot point because look at the grocery prices, look at the cost of gas within the last couple of weeks. So that's a moot point.
No. Now you have to listen to see what the governor says. What does the governor say? That's the cost of living gone up by 6%? I don't think so.
No, they said 3. She said she had said 3.
By
but
3.
I am saying But I am saying that based on our agreement, it does not say that. It says we get it. It doesn't.
So let's hold on then. So let's go back then. So when they drafted the industrial agreement, what was the basis and the rationale for the 6%? How did they arrive at that figure?
I guess because they did their survey and everything at that time.
Okay, so that's
Because
where
the
they're gonna
agreement was-
argue. They're
the
gonna
agreement was
argue back.
signed-
Yeah. When
It
they
was signed
argue,
5 years ago.
right. So when they argue, they're gonna go back to the formulation.
No, that's fine. But I'm saying everybody knows that the cost of living has gone up tremendously.
Yeah, it has gone up, but it's
Yeah,
not 6%.
No, they said 3.
Okay.
Yeah.
Yeah, if they say 3 and you get 3, that'll be more realistic. I think
Right.
even if you take that to court, they won't give you 6%.
Okay.
Yeah.
Well, they said 6, so we're looking for them to live up to that expectation because they hiring left, right, and center. That ain't my problem.
Well,
They hiring on the top, right?
You
Lyndon? They hiring
understand?
from the top.
They ain't bringing
What
in no
costing them-
little clerks
what
and
costing
things. They
them
bringing
more?
in. Okay.
They hiring from the top. What costing them more?
You
Costing them
understand?
more.
All right then. So
Yeah,
that's not gonna be my issue.
You must tell the class where you got the 6%.
I will definitely let you know.
Good luck.
Yeah, yeah, I agree.
Thank
I
you.
agree with
Thank you. I claim it. Thank you.
her. Yes.
I could use
You
that.
should
I'm
do-
getting ready to retire. I could use that. Make my little
That's
retirement
6%.
package look little good. Yeah.
Mm-hmm. So those are the actions taken. I think we've gone through these. I don't need to read this. So I think this was a good one. This was a good class. So you know this is on the exam, this chapter, without a doubt.
Yes, ma'am.
Without a doubt. Yes.
Ma'am.
So I don't know if I have any cases for next class. If I do, I will try between Tuesday and Wednesday.
And could you please use that email address for me? And
Yes, I wrote it down.
Thank
I wrote
you.
it down as a reminder.
So I could get them in time to.
In
to
time,
read them and
yes.
actually,
Yeah.
to read them and get them up and be up to speed instead of waiting for last minute.
All right. So those who did who are going to do the supplemental next week, best of luck.
There's a message for you, Ms. Archer, please.
Any study guide? Any study guide for the makeup?
A study guide.
Any study guide for the makeup? Just asking.
It's no more.
Miss
Ms.
Archer,
Archer, can someone forward it to me, please? Because I didn't get it.
Miss Archer.
Yes.
I think but I know I'm gonna be trying to take that exam again on Saturday. So we will be having class next week though.
What, next Saturday?
Yes.
Yes, we have class. Why?
The exam is at 1. I was just asking.
Oh, you have class in the morning. Our class should not be long. So I won't do that to you. Let me see, Monday, Tuesday, Wednesday. What I will do is for the midterm, for the makeup midterm, I will send you, I think it's only, 2 or 3 cases that you may need to read. Did you read any cases?
Yes, I did. Yes.
No, I mean in the first part, not now.
No, we didn't read any.
Okay. Let me send you some cases that you may need to support your answers.
Can someone
For
send me
the
the email
for
from
the makeup we're having on Saturday?
Yes.
Okay.
Yeah. Let me
Can
make a
someone
note.
forward me it, please?
What's that?
The email from Ms. Dean.
Supplemental, Miss Dean. Did she put me in that? I'm looking now. No, she didn't.
Okay, I'll
No,
probably
no.
speak with.
But I sent her an email, I sent an email with your email address.
I sent it to you, Kendra.
Thank you. I was just going to say, I was looking to see if you were still in class. I say I was probably going to reach out.
Okay, I'll send you some cases for those who want to do I'll just send it to everybody.
Okay.
I'll send you some cases for the supplemental.
Okay.
Yeah, since you didn't read any cases.
I got it, Palacious. Thank you.
Yeah, all right.
No problem.
Okay. All right, so get ready for that. Yeah, I won't keep class long next Saturday since I know you have an exam to take. And for those who didn't, they can start preparing for the final exam. Which is
And you're
very
gonna
close.
also send us our cheat sheet for that, right?
No, we're gonna discuss that in class.
Okay.
Yes.
All right.
Yes.
Okay.
Then say our assistants, don't say cheat, man, because we know
Sorry, our assistant's sheet.
when
Our
lectures say
assistant's
cheat, they start to get party. So just
Sorry,
say you
sorry.
send us our
Sorry.
assistant.
Yeah, Miss Archer, if you could send some cases that could help us in the final, we could start preparing for that.
Okay, yeah, not a problem. I'll do that.
This Ms. Archer,
Okay.
the structure
Also,
for
Ms.
the next
Archer.
short answer.
Hold on.
Hi, Ms.
Peter and Gabrielle was speaking. Go ahead.
Okay, this is Glenicia, actually. I'm
Oh,
using
okay.
my daughter's computer. Yes, I was wondering if you can consider giving us multiple choice for the final. I know you mentioned.
You missed the first class. And she told us off the back.
No, not
You not
multiple
confident.
choice.
No, it doesn't hurt to still ask.
I agree. I would you don't mind me. I would
Come
you.
on, guys, let's vote for this.
Multiple choice?
Short answer
Yes,
something.
multiple
voting,
choice or
voting.
short. Come on, you got to work with us.
Short answers is what I'm giving you. I need to see that you
Short
understand. That you
want to lift
understand.
Some multiple choice.
That don't sound too bad.
Do a mixture.
But
Some
y'all had
multiple-
multiple choice in the midterm.
Only
That was not
only
bad.
two. That was only two.
That was only about 4.
That was only two.
Multiple choice is not necessarily the easiest ones, man. At least if you're right, you could explain and get part of the points.
True. True.
Sasha, I have a question concerning the capstone question, please.
Go ahead.
Is there a point allotment for each question? So you kind of have an idea of how much it is you should be writing, like the kind of detail you should be
Yeah,
giving?
I was wondering about that as well.
Normally, it depends on the questions. I'll tell you for next class. So I normally don't put I can do a point for it so you could have an idea.
Yeah, they want to have an idea as to, whether I'm
Or just in
providing enough
general
detail or
As
not.
to how you
Okay.
expect the response to be.
Okay.
Sorry,
all
and
right, I
also
can
with
do
the
that.
survey, is there a number on like how many surveys we need to conduct?
No.
Okay, all right.
No. Okay, I give you the points and cases for the supplemental exam. All right. You're
So next
seriously,
week, if you just want to
asking
do it for practice, is that okay, Ms. Archer?
What's that?
If we're doing the supplemental, we just want to get a feel for, I guess, the style. Can we still do the exam just for practice, if that's what you so choose?
Yeah,
to do?
just put practice on it.
Okay, all right. Thank you.
Yeah. Because as you see, the format on the supplemental is how the final exam will be written.
Right, okay, thank you.
Yeah.
Is
So
the
you can-
supplemental available virtually?
You can get it after they've taken it.
No, I meant because I'm in Eleuthera, so I wouldn't be able to physically attend the
Oh,
exam.
okay. Why don't you just send a note to Ms. Dean? Because you wouldn't need an invigilator. You just be doing it just for practice.
Right.
Correct? Right.
Yes.
So she can send it to you and then you send it back. Just tell her you're doing it for practice as agreed with the lecturer.
Okay.
So you can do it in the time allotted and see how you do.
Yes. Okay.
Yes.
Thank you.
Okay. So just let Ms. Dean know.
Okay.
Okay. Not a problem. And you'll have an idea of my style of how I write the exams.
That's the part that keeps me up at night.
It's not too hard. You just have to think think and answer. And my answers in the exams are never very long,
Okay.
but the questions are very difficult.
What?
Oh, okay.
Yeah. You'll see.
Lord,
All right.
You'll see. But it's a good, it is a good practice. So when you go in the exam, see, if I had you for the whole thing, then you would know from the midterm how the finals will be.
that's true.
Yeah.
Yeah. But you have to study.
Okay.
What happened now? Where is around there going in?
I'm very afraid. I'm very afraid.
No, do not be afraid.
It's been a good class, but it's a lot.
It is a lot. It's a lot. But for the finals, I will direct you as to what areas will be covered. That's the first thing.
Okay.
At least that'll narrow it down a bit.
That narrows it down. But then
Yes.
remember what I said, just like how we did the one just now with what's her name? The lady.
Jerry Brown.
Miss Brown. You realize that it went back to the duty of trust.
Right.
Yeah.
So those duties on both the employee and employer side, they're the bread and butter of employment law. Especially when you're talking about breaching your contract.
And Ms. Archer, one thing I know, like sometimes when we're having discussions, because we are novice to some of the terms, we may not explain it. We can explain it, but we may not know that exact legal term.
That's
Is it
fine.
Penalized.
No.
Okay, all right.
Just based upon what you write, I will know that you understand. See, that's why I'm saying the multiple choice will not work. Because if I give you a scenario, I'll be at the end of the day know that you actually understand whatever is the principle that we're trying to discuss. Like you understand sections 35 to 40 of the Employment Act. You know what misconduct means. Because if I ask you what misconduct is in the multiple choice, you know it's the list that's in the act, and like the only thing you could do is throw in one or two terms that don't fit in. That doesn't explain to me that you understand what that means. It's just a selection. So just get prepared for the what I can do is tell Ms. Dean that all of you will take it and some of you will just do it as a practice. You want me to do that?
Yes, ma'am.
Yes, ma'am. At least for me.
I mean, I hadn't planned on taking it, but I mean, I want it so I can prepare for the final.
That's what I'm
I mean,
saying
I
now.
could get it after, yeah.
Okay, you could get it after. Or you could get it when she sends it. And you just put on yours for practice. And then you just send it back and tell her you're practicing it, but you won't resend it in.
Yeah, I don't want to take that chance and my score is less with the supplement.
No, you're not taking it. Just put on it and just put on the top of your submission, practice.
Okay.
So whatever you could answer, you answer. But put on it, practice. And I'll just tell her all students will take it.
So is this an in-person or is this something that's going to be sent to us?
I think it's in person.
Okay.
Yeah. So those who are doing it as practice, she just email it to you, correct?
Correct, yes.
Okay.
You can email it to me.
So you need to identify yourself to her.
Oh, another thing, Ms. Archer, the final exam, I had mentioned to Ms. Dean already that I would want to take it a little bit early. Because
That's fine.
Okay.
Yeah, once you tell her the date, she'll have the exam ready for you. So I say those who are taking it for practice can receive an email version at 1 p.m. on Saturday. Okay, I've sent that to her. Let me put this in bold. Okay.
So the supplemental we're having, Ms. Archer,
Uh-huh.
is going to consist of the first portion of the book and possibly something that you're going to be sending us on Wednesday.
Yes.
Okay.
Yes.
Okay.
I'll send you the cases you need to read that will assist you in answering the supplemental exam.
Okay.
Okay, so that went to Ms. Dean already. Okay, so those who are taking it just for practice, let Ms. Dean know. So at 1 o'clock, you will get it. And the others who are taking it for grade, she will arrange for you to come in and take it.
Okay.
So let me find some cases that could help you answer the questions.
Okay.
All right.
All right.
All right, so get started. You need to review, and then I'll send you the cases.
All right.
Okay?
Yes, ma'am.
All right. So enjoy
Right.
the rest of your weekend. Spend some time studying because
ma'am.
Saturday will come very quickly.
Yes, it sure does.
It sure does.
Very, very quickly. All right?
Yes, ma'am.
Okay. All right. Have a good weekend.
You too.
All right.
Take care, everyone.
Okay.
All right, see you later.
Okay. Bye.
Bye.